This is Talkin to America. I'm your host, Aaron Zellman. Our special guest today is David T. Hardy, attorney, author, and scholar. Today we're going to be talking about a very important court decision. It's called the Parker case. As the decision stands now, a particular court has said that you have an individual right to own a firearm versus the story that the gun control folks have put out about it's a collective right. So, David, let me start by asking you, how did the Parker lawsuit come to be?
Well, it was brought by a couple of attorneys, Bob Levy and Alan Gura, who thought they could challenge the District of Columbia law, which prohibits handguns and requires long guns to be kept disassembled or trigger locked. And they essentially decided to bring the lawsuit in the District of Columbia federal court and to challenge it in that venue.
Why would you suggest that they pick the District of Columbia?
I think that was a very, very intelligent choice. There are several reasons. One is that when they went on appeal from there to the Circuit Court of Appeals, the next rung up, the D.C. Circuit was one of relatively few federal circuits that had no prior decisions on the Second Amendment. Most circuits, if you went up, what would happen would be no matter how convincing your argument is, they go back to, well, we've previously ruled that the Second Amendment is not an individual right, and we're going to stand by that precedent, and you have a convincing argument, but we're bound by our prior decision, so go away. D.C. Circuit, that isn't true. They didn't have a decision on the Second Amendment being an individual right one way or the other. The other thing is that in most gun laws, if you want to challenge them, are at the state level. With the states, it's a bit difficult to explain, but it's called the incorporation issue. The Second Amendment, like most of the Federal Bill of Rights, actually was adopted as part of the federal Constitution. And the Supreme Court, over 100 years ago, ruled that the Federal Bill of Rights only affects Congress, only affects the federal government. If you want to have an individual right against your state, you ought to put it in your state constitution. That changed under the 14th Amendment, 1868. And it was a very complex process, but basically the Supreme Court started saying that some of the rights under the Federal Bill of Rights actually do apply against the states, but it's never got around to saying that the Second Amendment does. So if you're challenging a state law, you have that problem. The court can also brush you off by saying, well, the Supreme Court has never said the Second Amendment applies to states, so go away. If you challenge the District of Columbia law, you don't have the problem because D.C. is entirely a federal creation. It's not a state. The third reason was why it was such a good pick was that D.C. has such an absolute law. I mean, you can debate, whether this is this law or that law is a reasonable regulation of a right. It's pretty hard in the case of D.C. to argue that because it totally bans ownership of handguns and requires that long arms be kept either disassembled or trigger locks or they're useless for self-defense. It's very, very difficult to argue that the D.C. law is anything like a reasonable regulation. It's an outright ban. So for all those three reasons, I think D.C. was an excellent target for a lawsuit of this type.
Well, okay, why don't we talk about then what the D.C. Circuit Court of Appeals ruled?
Well, the D.C. Circuit essentially took the case and ruled that in terms stronger than the Emerson decision, which came from the Fifth Circuit some years ago, ruled that the Second Amendment is an individual right, that it does pertain to individual citizens, that it applies to D.C., and that the D.C. law is unconstitutional. They made some reference to the fact that maybe a reasonable regulation is allowed, but then said There's no way you can class this as reasonable regulation. It was, I think, a stunning opinion. It went farther than Emerson. It actually struck down the law, which Emerson didn't. The Emerson case essentially, out of the Fifth Circuit, which is Texas and Louisiana, had said that this is an individual right, but then it said that the gun law at issue, the federal ban on domestic violence, I forget whether it was restraining orders or conviction. I think restraining orders said, well, this is about as far as you can go and still call it a reasonable regulation of a right, but we're going to allow it. So the Emerson case out of the Fifth Circuit upheld the gun law in question, even though it said it wasn't, the Second Amendment was an individual right. Well, the D.C. Circuit went farther. Yeah, it's an individual right, and we're striking down this law. For that reason, I think Parker is a stunning decision. It is a stunning ruling in favor of gun owners.
I'm wondering, what kind of feedback are you getting from other attorneys and people in the pro-gun movement concerning the Parker case? For the most part, everyone is happy to have Parker. The only division is between those who rejoice that it may go to the Supreme Court and those who worry that it may go to the Supreme Court and those who do both. That sort of thing. I mean, anytime you're talking about an appeal, you're rolling the dice, and you're never quite sure how the dice are going to turn up. So that's the division there. Do you worry about it or do you rejoice about it? Well, do you think the D.C. Circuit Court is going to appeal to the Supreme Court, filing a petition for certiorari? Well, it wouldn't be the D.C., but the D.C. government itself, the defendant. Will they? I would have said almost certainly. Now I don't know. There's some articles in the Washington Post where both the Post and the D.C. government sounds like they're scared, worried about the outcome, as they should be. And there is an outside chance that they wouldn't take the appeal. I think it's only an outside chance because they've got so much invested in it emotionally and otherwise. To just roll over and die on it, they would have, first of all, they'd appear in the eyes of the world as losers who were scared of taking it to the Supreme Court because they knew they'd lose, which would be the truth. Secondly, they'd lose their precious gun law, which, while it hasn't done any good for anyone, in their eyes, they have an emotional investment there. So the other thing from the general anti-gun side is that D.C. Circuit isn't just a circuit court of appeals. You have jurisdiction to sue the federal government in D.C. Circuit anytime you want, even though the harm to you occurred in California or Nevada or Alaska. You can sue where you were hurt, or you can sue the federal government in D.C. It's as if the federal government lives in D.C. You can always go to a person and sue them where they live. If you let this precedent stand, you've got precedent in D.C. that it's an individual right, and every single federal gun law is wide open to challenge in that court. So I tend to think they're going to take it up, that they're going to move in the Supreme Court for certiorari. I can't guarantee it. They may chicken out at the last minute, you might say. Okay, well, would they be chickening out because of the points that you've made here? Yeah, that was just what the Post was saying. Yeah. Complaining that, this is it's a conservative court now, and maybe they don't want to take it up. No, it's no more conservative than it was beforehand. It's just that you're scared. Well, while you're on that point about a conservative court, correct me if I'm wrong, but this is the court that thinks the Patriot Act is okay, and this is the court that had the eminent domain ruling, which is horrendous, and this is the court that doesn't seem to have a problem with the warrantless tapping of people's phones. So why would they be enthused about individuals having a right to own firearms? Well, I don't know if Roberts and Alito were there for all of those rulings, but